Hello, this is C. Paul Singh, President of NISWA. A very good evening, and thank you all for joining us at the 124 edition of our webinar on the subject Misuse of Technology, Impact on Privacy of Users. I'm sure that the delegates from various countries who have joined us shall enjoy the deliberations and would listen to the presentation of our erudite speakers and carry home very important points from these deliberations. I extend warm welcome to all of them, and particularly to our two eminent speakers today. Let me introduce in a few words NISBAT, National Institute of Security, Safety, Management and Applied Technology, was established in 1990, about 3 decades back, started training courses in the private security sector in these subjects, in these spectrums. We also conducted courses for the Ministry of Defense for providing second career to the retired defense personnel to join private security. NISWA today aspires to become the foremost corporate training institute and think tank in the field of security and safety. It started the process of creating research cell a few years back, and today we have a number of scholars on our forum. NISBAT has established 4 wings. First is NISBAT Forum. NISBAT Forum organizes webinars, seminars, conferences, and interaction programs, debates, and speeches by scholars, as we are going to have today. Then we have the NISBAT Academy. NISBAT Academy conducts virtual training programs and assessment certification. Then we have got NISBAT Enterprise, that is conducting audit and verification. It is a sort of a business enterprise, one of the business sectors of NISBAT, and it conducts audits, verification also in the field of, again, safety, security, applied technology, and also enters into alliances and partnership. And last but not the least, we have the NISBAT Foundation that undertakes welfare and social work for the society at large with and is going to launch its program in future. Introduction of the chairman. I would like to introduce Mr. Pawan Ahluwalia, who is the chairman of Ahluwalia Holding Group, which has offices not only in India, but all our locations in India, not only in Delhi, but all our locations in India and abroad. Took voluntary retirement from the regiment, parachute regiment, and as a young officer, and jumped into an unknown area of business. With his continuous hard work, continuous perseverance, and taking an attitude which at times saw the pitfall yet did not fall into the pitfalls and learn from the pitfalls. He has grown, he has evolved, and has achieved a position of prominence in the world of business today. Founder member of the International Business Research Association, Hong Kong, and also a member of the World Association of Detective USA. He is the past president and former chairman of Council of International Investigators USA and is awardee of Malcolm Thompson Award and Kotalia Award by this council. Pawanji Ahluwalia shall moderate this session. Now, before I hand over the proceedings to Mr. Pawanji, I'd like to introduce the subject of today: misuse of technology, impact on privacy users. Now, privacy as such let us understand the right to privacy is recognized as a human right which emphasizes human dignity and cherished right of an individual. In most of the countries, there is a legal and constitutional protection for the right to privacy. In Indian context, the historical judgment of the Supreme Court in 2017 established that right to privacy is also one of the fundamental rights and is derived from Articles 4 or 14, 19, and 21 of the Constitution. But right to privacy has been subjected to some reasonable extent, they say, restrictions are there for safeguarding or to safeguard the security and sovereignty of the country. There are some other courts, there are some other enactments to safeguard privacy of data, like the Information Technology Act of 2000 and amended in 2008, and also it lays down the punishments for various offenses. Information Technology Rules 2011 protect sensitive personal data. A bill 2019 is also under consideration. However, on some grounds, the persons authorized by the government can or do undertake acts which intercept or monitor information of an individual. Thus, the need for a separate law to protect privacy of the individual has been debated and emphasized by some legal experts. The misuse of technology is undermining the rights to privacy. The technology, it facilitates collection, processing, and so-called interference in the personal data. It facilitates that. The misuse impacts the privacy of an individual by assessing the individual's information, which is of personal nature. The misuse is not only a challenge to the privacy, it also raises certain ethical and judicial issues. And it compromises, according to me, the freedom and autonomy of any individual. Thus, any data about an individual should not be interfered. The social, ethical, and legal implications of the misuse of technology needs to be understood and checked at all levels, particularly I said at two levels, that is individuals, business rivals, and the government. Now, the areas of unethical interference are known to us: the interceptions and reading of the email messages, the merging of database called data banking, the rise of hackers, the rise of crackers, decoding digital information. The professional who deal with the proceedings of information must realize that manipulation of any private and personal information is a serious matter and impacts the norms of freedom, truth, and human rights. With these words, having introduced the subject, I do not want to stand between you and a learned scholar who are going to speak on the subject. I now pass on the proceedings to Mr. Pawan Ahluwalia to moderate this session. Thank you very much.
Uh, Thank you, Mr. President. I'd begin by thanking the sponsors for the event today. The event is sponsored by Premier Shield Private Limited, which is a manned guarding services. And the whole event is also supported by Premier Consulting and Investigations Limited, India Skills Private Limited, and Tag Scores, which is an examinations platform, and by a cargo company called JMD Cargo. Today we have participants from the following countries: India, USA, Singapore, Bangladesh, France, Guyana, Kenya, Nigeria, New Zealand, UAE, and the United Kingdom. We are at this point of time live on YouTube as well as on Zoom. I take a minute to introduce our illustrious president, Mr. Sipal Singh. He's a master's in English literature, and he has served the Union of India in very senior police appointments in all the states of this country. He was made responsible by the government of India to raise a new force called the Rapid Action Force. He was thereafter appointed its first chief and remained so for a number of years. He then went on to raise the Internal Security Academy, which is a central police academy at Mount Abu in the Indian state of Rajasthan. During his career in the police, he was decorated with the President's Police Medal for Distinguished Services, the Indian Police Medal for Meritorious Services, a Police Special Duty Medal with Bar, a Sena Medal, and a number of other commendation and rewards. After retirement, he was awarded as the Security Personality of the Year by the President of India in its Global Security Conference in the year 2009. He is currently an advisor with the Asian Professional Security Association with the Indian chapter. He is also the Honorary Director General of the Central Association of Private Security Industries in India and the Association of Private Detectives and Investigators in India. Mr. Sipal Singh's face is well known in the country as a dynamic security professional who has appeared in a number of interviews at the national television channels. It is now my proud privilege to introduce the first speaker of the day, and that is Sarah Jane Fox. Sarah specializes in law and enforcement, regulatory compliances, and law enforcement policing. She holds a PhD in law, where her research related to cross-border enforcement and the implications of the movement of people across set boundaries into other jurisdictions. In 2015 and 16, Sarah was awarded the Distinguished Fulbright Research Scholarship. Her research related to risks and threats to critical infrastructure, in particular to the transport sector. Sarah's current research focuses on technology, challenges and opportunities in society, including systems such as drones, space use, cyber preparation and penetration, and societal acceptance. Sarah has presented her research findings at various events and conferences to the United Nations and the European Council. She is the director of Online Hams and Cybercrime Unit. Sarah has worked in senior management roles as a legal and practice consultant to many government departments and advisory boards related to policing, transport, and security. She is a member of the International Commission on Security Law, a trustee on Lloyd's Tertiary Research Foundation Board. She is fellow of the University of Liverpool Law and a listed expert with the United Kingdom and European Union parliaments. She's a visiting professor at DePaul University in Chicago. Ladies and gentlemen, I now present to you Sarah Jane Fox.
Hello, friends, colleagues, distinguished guests. Good morning, good afternoon, and good evening. So I would also like to extend my thanks to NISMAT International for inviting me to talk today, and also the sponsors for sponsoring the event. It was quite a long introduction, so I would just add a few parts to that. So my name's Sarah Fox. You've got my contact details at the bottom, and they will come up at the end. So please feel free to sort of reach out to me if you have any questions after the event. So I'm going to talk a little bit about some of this areas where they cross over from the perspective of law, policy, technology and travel. So at the moment I'm working at Staffordshire University, and as I said, I work across a few research centres. So yes, the Online Harm Cybercrime Unit, the Centre for Crime Justice and Security, and the Centre for Smart Systems, Artificial Intelligence and Cyber Security. So to start with my presentation, I'm going to take you on a journey. So please buckle up, seatbelts on as we get underway. So I'm going to talk to you about sharing using data for travel, security and safety versus the privacy of users, and really looking at the conflict between safety, security, privacy applied to travel and movement. So we're going to be questioning acceptance and hopefully getting you sort of thinking about some of these sort of crossovers between safety, security and privacy, looking at misuse and questioning the concept of necessity and ethics, obviously as a factor too. So this slide shows you some examples of technology all involving travel and movement. Technology is literally all around us. It's what we use daily. It makes our lives easier and it helps to keep us both safe and secure. From a travel perspective, we expect to be safe and we expect to be secure. Taking the car, for instance, our cars are fitted with safety devices. And that throws into the question how we deem and define technology, because our technology on our vehicles starts from quite a minor perspective, so seatbelts, brakes, other sensors, and it varies in less levels of sophistication. Just going to say, I think some people may have their mics live, so I don't know if you want to mute your mics because we're just getting a little bit of feedback there. So we use technology to navigate our way around. We've got sat navs there. So we use advanced satellite systems for information. Then we have the more obvious, aircrafts, planes. And obviously if we fly out of the country, we need to use a passport to fly out. And of course, that now has biometrics within it. We also use phones and computers to keep in contact. And for me, from my research perspective, that's also a form of travel. In that instance, we don't move, but the information does. So we sit in the comfort of our home. So I've started to give you an idea of some definitions here. So I'm going to go through, how do we actually define privacy? So privacy has been actually defined for a number of years, in fact, hundreds of years. So legal scholar William Prowser separated legal privacy cases into 4 distinct areas. Intrusion, intruding physically or otherwise upon the solitude of another in a highly offensive manner. Number 2, private facts, publicising highly offensive private information about someone which is not of legitimate concern to the public. Number 3, false light, publicising a highly offensive and false impression of another. And lastly, number 4, appropriation, using another's name or likeness for some advantage without the other's consent. So remember number 1 and number 2, because we're going to come back to that a bit later. If you ask various people to define what privacy is, you'll get a whole host of answers. But in the conversation, you will no doubt have the likelihood that today it's probably involving some data breaches, wearable technology, social networking, targeted advertising. So if we think about Amazon, how many times you maybe go on and select something from Amazon, only to find in your inbox, in your computer sort of emails, you get masses of emails offering you the same product or a similar product months later. Did you want that? Is that intrusive? Certainly when we start to mention technology in the equation, we think of ethics also. It certainly should become part of the conversation. I'm going to just mention a quick publication here. So in 1997, Judith Wagner, DC, wrote a really interesting book, In Pursuit of Privacy, Law, Ethics, and the Rise of Technology. which took a legal and also a philosophical approach, were preaching the significance of technology, which of course has actually now moved on and become more advanced and arguably more intrusive. When we consider the law and what is acceptable, if we start to think about history and taking a UK perspective, so we go back to 1830s, it was said, for instance, that domestic violence was not something the police would actually become involved in, particularly when it was inside the privacy of someone's house. There was reluctance to cross that threshold, that doorstep, into someone else's house, unless the domestic was so violent that it necessitated intervention. Of course, we have a different viewpoint to that now. We've changed. If we bring technology into the equation, we know that child sexual exploitation, or indeed adult exploitation involving the intellect perpetrated by online means, is an offence, even when the internet is within a private dwelling. So have we actually reduced the concept of privacy? And is it acceptable in a person's own house? So I'm going to move on to some other definitions for you: safety and security. So an interesting concept, I know we've got people from all over the world, so defining safety and security. So some countries actually don't distinguish in their language between safety and security. So if we think about Spanish, seguridad, one word that covers both safety and security. So we can kind of see that can get mixed up a little bit. In English, the term safety is broadly used to refer to the protection of individuals and assets, to keep someone safe, to stop it being harmed, to keep it in one piece, normally related to the concept of an unintentional act, such as an accident. Whereas security, on the other hand, tends to be associated with a purposeful act against us by an external threat and criminal activity that can be directed against our assets or an organisation or a country. Today, it crosses over to the realms of physical security, but also virtual security, both of which I'll be addressing and discussing. We use technology actually to mitigate against both, to keep us safe and secure. But there again, there is a dilemma. Technology is becoming sophisticated and normally involves some type of data, be it diagnostic information or personal data. With technology innovation, information privacy is becoming more complex by the minute as more data is being collected and exchanged. When we use technology, we rarely question the risks because of the advantage. But every use leaves a trace, and it's the same principle, forensic principle, that you would find Locard's principle. So sat-navs, as we see there, might actually keep us physically safe, but stand to compromise our physical security. They can make us vulnerable because you program into that your home address, you program in your times, and you program in your routes. If a car is stolen, you've handed the thief data that could result in secondary crime, maybe a burglary of your home or your personal safety. So principally, technology doesn't actually have to be misused. It's really any use that can infringe upon our privacy and security when in the wrong hands. Technology can be used to exploit us, misused. It is both our saviour and our nemesis. My talk concerns Prosser's first and second definition, but I'm going to leave out the highly offensive concept and manner. So intrusion, intruding, physically or otherwise, upon the solitude of another, and private facts, using private information about someone which is not legitimate, used or is excessively used. So I'm going to pose you a few questions. How much risk are you willing to take? Do you value your privacy above security or above your safety? Are you happy to accept a reduction of privacy if it keeps you safe and secure? Are your concerns centered around government use of data and use of technology, or private industry, particularly large corporations' use of it? So I'm just going to move on to a couple of slides, and I'll let you quickly have a read of these. So, Universal Declaration of Human Rights, which was touched on, 1948. So number 3 that you can see there, life, liberty, and security of persons. But that actually causes a potential conflict, a balance and acceptance. And then there's another one that we're going to bring in here. So we're also now looking at the area of privacy. This is the one that we're kind of touching on today. But if you look at this, there is another aspect to bear in mind. It's arbitrary interference with privacy. So again, what is acceptable in terms of keeping you safe and you secure? I'm going to touch on another one that you may not actually pick up. Or you can see this is where my presentation is actually going. And that's in relation to travel. So you have the right of freedom of movement and residence within the borders of your state, and you have the right to leave your country, including returning to it. So let's just go back a little bit. 20 years ago, we're nearly at the 20th anniversary, 9/11. So 20 years ago, 9/11 was a massive security event that impacted upon our privacy. It changed us and it challenged society. So in other words, it challenged us and it changed society because the two go together. So 9/11 was one of two events I'm going to speak to you about. So two events that have been significant in the last 20 years to us all, regardless of where we live in this world. In this case, it started with technology in the wrong hands, an aeroplane, used for the wrong purpose as a missile, to take lives and cause massive destruction and actually lasting consequences. The day that changed the world was a phrase that was written by Bizignani, International Air Transport Association, when he commented in a publication. But it actually led to stopping of international movement. So it actually stopped us moving for a period of time. And it has significant consequences, obviously, on the aviation industry, but on a result of us traveling. So advances in safety, so bringing in a little bit of safety. So we've seen actually planes become safer in many ways. In some times it hasn't always worked. So if we think about the Boeing 737 MAX was a flawed product whereby there was no loss of privacy, but loss of lives due to the technical issues associated with the aircraft. Arguably though, the diagnostic information and data that was transferred back was used to rectify it. So we see data being used positively. We have a consequence where history does repeat itself. So there is a sequence: revolution, evolution, technology increases, we evolve, technology increases, then there is technology revolution, we evolve, and so on. So there's a link to it. So today's revolution, where are we? Are we, depending on what you read, arguably in the fourth or the fifth industrial revolution? So a way of describing actually where we are now is the blurring of boundaries between the physical, digital, and actually even biological worlds. It's a fusion of advances in artificial intelligence, robotics, the Internet of Things, 3D printing, genetic engineering, quantum computing, and other technologies, which will lead to humans interfacing eventually more advanced technology, which could mean our data will also be fused with machinery. With 9/11, there was an increase in security. Was it too much? Did it lead to an acceptable reduction of our privacy? Biometrics were brought into passports. We had to walk through, those things, those intrusive machineries, those body scanners, certainly until our imagery could actually be anonymized and our body parts not actually exposed. In terms of security then, was it overused? Was it misused? Were we exploited because of technology? How much is appropriate and how much is acceptable to you? So the last one there, transferring of data, passenger names, records, total controversy surrounding that one. The US required more information after 9/11, held airlines to provide this information, or it would stop them flying into the US, or they could be heavily fined. Airlines had to provide passenger information units. So what it was within that data, PNR data consists of the information on individuals provided to an airline electronic reservation system. So how much of this is acceptable? Dates of travel, travel itinerary, ticket information, seat number, baggage information, travel agents or other method, Your contact details, like your address and your phone number, your payment information, and potentially other sensitive information such as meal preferences or special needs that could indicate ethnic origin or religious beliefs. After 9/11, there were lengthy challenges in US agreement with the EU, so the EU agreement for this PNR. And it started, obviously, after 9/11, 2003, 2004, saw a tentative agreement. But one of the early agreements was actually challenged by the EU for overstepping powers, the competence to act, the consequence of sovereign nationality and legal use, and the involvement of law enforcement agencies. And it wasn't actually until 2012 that a final agreement was reached. So 2012, they reached this agreement for sharing data. The EU has increasingly taken a very strong stance on privacy and rights of EU citizens, but it actually obviously affects everybody across the world. In 2016 came the regulation, didn't actually come into effect until 2018. And the regulation is on the protection of natural persons with regards to processing of personal data and on the free movement of such data. So it's linked into movement again, which, as I say, didn't come into effect until 2018. But it's the one that's probably one of the strongest, toughest in the world. And it links into the 1950s European Convention on Human Rights. So it was based very much similar to the Universal Declaration of Human Rights. However, as we know from domestic and child sexual exploitation cases, there has to be exceptions where we need to be challenging some of this. So in the period 2019-2020, there has been significant judgments and decisions from the EU. Consequently, now in 2021, this has impacted on the PNR agreement, so the name agreement for sharing data between the US and the EU. So actually, it's been declared no longer valid, and this was due to EU judgments, as within the Schrems 2 court case concerning Facebook and the Canadian EU passenger sharing agreement decision. So the US didn't meet the EU adequacy for transmitting sufficient protection for the users of information on the flights to the US. But what about traveller security now? Has that now been compromised? Certainly some nations, Germany for instance, have raised concerns, and currently we're still in a situation where this hasn't been resolved. So the EU is negotiating with the US with regards to the transmission of the data and affording sufficient protection. So we've now seen that the US possibly don't take the same level of protection. 2 court cases here, and this includes technology giant Apple. So the protection of Apple was stronger than the US government, both related to security terrorist attacks. So in 2015, there was a California shooting, which was terrorist attack. The government wanted access to Apple via backdoor, and Apple actually opposed it. And it went very quiet, and people didn't understand why it went quiet, but actually the US approached Australia, and an Australia company managed to enter the back door. So where do you stand on that? Do you support the government because it's a terrorist effect, or do you support Apple? So far I've spoken about security and privacy. 2021. COVID-19, the other significant event that I've mentioned that's occurred in the last 20 years. It's affected us, well, regardless of where we live in this world. 20 years after 9/11 this year. It's also led to restrictions of our movements as well, borders being closed. And as a result, we've increasingly relied on the internet to work, to communicate with friends and loved ones. We've had restrictions placed on us by governments. Is that acceptable? Which are able to restrict our movement for security, health, and safety reasons. But this technology has also given opportunity for abuse, as people have been able to plan potential attacks in the virtual and physical world. We're increasingly shopped on the internet and compromised our details, which could lead to fraud. The irony is that technology now allows for attacks, security threats and abuses to be perpetrated more easily remotely. And we would have difficulty locating the culprits and bringing them to justice should an event like 9/11 actually occur through remote hacking of an aircraft. We have a lack of protection legislatively to coordinate and fight such crimes. And actually, it could place us in physical harm. It's nearly there. So we've actually now gone full circle. So I've said I've spoken mostly about security and privacy, but what about this debate? Sharing of data and information, again for travel, but this time for safety versus privacy. From the EU perspective, we're quite lucky, although obviously from the UK, we're not in the EU, which is, of course, another discussion. But from an EU perspective, the GDPR offers a good protection, and we're seeing that the EU will take action if it compromises privacy. But the same can't be said across the globe. This is a quotation from the New York Times. This is a US perspective, remembering that they've already been deemed that their adequacy doesn't provide people with sufficient protection.
Sarah, try and conclude. You're running out of time.
So finally, I'm just going to touch on my research. So I actually hopefully I was near enough there on the timing. So this is some of my linked research that talks about mobility and free movement, policing the technology revolution. How do we do it? Disruptive technology, where are we today? And actually, yes, drones, and I know India had an issue a little while ago with regards to some of this. Police cooperation, sharing of information, good or not so good, and 9/11 just on the last one. And there are my contact details for you. So please do drop them down. And thank you for the invitation again to speak to you. Thank you.
Thank you very much, Sarah. What a wonderful talk you've given. And now I'd like to introduce the second speaker of the day. That is Mr. Anup Bose. Anup is an internationally reputed senior lawyer practicing in the Supreme Court of India and also various high courts and tribunals in India. He has been closely associated with some of the topmost Indian corporates like Tata Sons, Reliance, ITC, Hindustan Levers, Indian Oil, ICI Limited, amongst many others, as a lawyer and as an advisor. He addressed a select gathering of member parliaments and other eminent persons in the House of Lords, United Kingdom, in 2009, and was awarded the prestigious Ambassador of Peace Award. He was also invited to the House of Commons in the same year, and later to Chatham House and the Universal Peace Foundation in London many times. He's an avid debater, public speaker, writer, broadcaster, telecaster, artist, painter, sculptor, and a music critic and a filmmaker. He loves Western classical music and has a very large collection of the same. Ladies and gentlemen, I present to you Anup Bose.
President CP Pal Singh Ji, Pavan, Sarah, and my fellow participants from all corners of the globe. The word privacy has been derived from the Latin word privatus, which means set apart. The recognition of privacy is deeply rooted in history and religion. The prodigious English writer Eric Arthur Blair, popularly known by his pen name George Orwell, in his dystopian 1949 novel, 1984, visualized a totalitarian state where advanced technologies would be used to monitor the people in all their endeavors. The big brother would be watching us, and privacy would be a thing of the past. Here I'm irresistibly drawn to Orwell's words. Always eyes watching you and the voice enveloping you. Asleep or awake, indoors or out of doors, in the bath or bed, no escape. Nothing was your own except the few cubic centimeters in your skull. Human beings indefatigably value their privacy and the protection of their personal domain of life. They certainly do not want their personal information to be accessible to just anyone at any time. But recent advances in information technology threaten privacy and have reduced the amount of control over personal data and open up the possibility of a range of negative consequences as a result of access to personal data. In the second half of the 20th century, data protection regimes have been put in place as a response to increasing levels of processing of personal data. The 21st century has become the century of big data and advanced information technology, example, forms of deep learning. The rise of big tech companies and the platform economy, which comes with the storage processing of exabytes of data. The revelations of Edward Joseph Snowden, the Cambridge Analytica case, and more recently, the Pegasus snooping case, have demonstrated that worries about negative consequences are real. The technical capabilities to collect, store, and search large quantities of data concerning telephone conversations, internet searches, and electronic payment are now in place and are routinely used by government agencies and corporate actors alike. The rise of a resurgent, assertive communist China and the large-scale use and spread of advanced digital technologies for surveillance and control have only added to the genuine concerns of even ordinary citizens all over the world. For business firms, personal data about customers and potential customers are now also a key asset. The scope and purpose of the personal data-centered business models of big tech, Google, Amazon, Facebook, Microsoft, Apple, has been aptly described in detail by the celebrated American author, Harvard professor, social psychologist, philosopher and scholar, Shoshana Zuboff in 218 under the label Surveillance Capitalism. And now, without any further, let me come straight to the three cases which have made history in recent times: the Snowden, the Cambridge Analytica, and the Pegasus cases. On 14th of June 2013, United States prosecutors charged Snowden, a former computer intelligence consultant, with espionage and theft of government property. In late July 2013, he was granted a one-year temporary asylum by the Russian government, contributing to a serious deterioration in Russian-American relations. On 6 August 2013, US President Barack Obama made a public appearance on national television where he told fellow Americans that we don't have a domestic spying program and that there is no spying on Americans. Towards the end of 2013, October, the British Prime Minister, David Cameron, warned The Guardian not to publish any more leaks or it would receive a DA notice. In November 2013, a criminal investigation of the disclosure was undertaken by Britain's Metropolitan Police Service. In January 2014, Obama said that the sensational way in which these disclosures have come out has often shed more heat than light. In its first assessment of these disclosures, the Pentagon concluded that Snowden committed the biggest theft of American secrets in the history of the United States. Sir David Omand, a former director of the Government Communications Headquarters, commonly known as GCHQ in London, describes Snowden's disclosures as the most catastrophic loss to British intelligence ever. In March, the New York Times, working with the Observer of London and The Guardian, obtained a cache of documents from inside Cambridge Analytica, CA, the data firm that was principally owned by the American hedge fund manager and computer scientist Robert Leroy Mercer. The documents prove that the firm, where the former White House chief strategist in the Trump administration, Stephen Kevin Bannon, was a board member, used data improperly obtained from Facebook to buy voter profiles. The news put CA under investigation and thrust Facebook into its biggest crisis ever. The Times reported that in 2014, contractors and employees of CIA, eager to sell psychological profiles of American voters to political campaigns, acquired the private Facebook data of tens of millions of users, the largest known leak in Facebook history. The New York Times first showed how CIA received warnings from its own lawyer, Lawrence Levy, as it employed European and Canadian citizens on campaigns potentially violating American election law. The Times also found that tranches of raw data existed beyond Facebook's control. The Times reported that people at CIA and its British affiliate, the SCL Group, were in contact with executives from Lukoil, the Kremlin-linked oil giant, as CIA built its Facebook-derived profiles. The articles drew an instant response in Washington, where lawmakers demanded that Mark Zuckerberg, Facebook's chief executive, testify before Congress. Democrats looking into Russian interference in the 2016 American elections demanded an investigation into the leak. They were echoed by lawmakers in Britain investigating CIA's role in disinformation and the country's referendum to leave the European Union. Significantly, CIA has worked in India through an Indian company called Strategic Communication Laboratories Private Limited. On 27th of May, 2018, Christopher Wiley, the Canadian whistleblower, computer expert, and data consultant, sparked a global debate over electronic piracy when he told the British Parliament that CIA had worked extensively in India and named the Indian Congress Party as one of the political parties in India that had used the services of CIA. In November 2019, a tech reporter from New York photographed an interception device displayed at Millipol, a trade show on homeland security in Paris. The exhibitor, NSO Group Technologies Limited, NSO Group, an Israeli technology and cybersecurity firm founded in 2010 by Liv Kame, Omri Lave, and Shaleh Julio, placed the hardware at the back of a van, ostensibly for convenience of portability. This was the first time that an NSO group made portable base receiver station, BTS, was featured in a media report. A BTS, a rogue cell tower, or IMSI catcher, or Stingray impersonates legitimate cellular towers and forces mobile phones within a radius to connect it so that the intercepted traffic can be manipulated by an attacker. The BTS photographed in 2019 was composed of horizontally stacked cards, likely to allow interception over multiple frequency bands. The capability of launching network injection attacks performed remotely without the target's engagement, hence also called zero-click or knowledge, gave Pegasus, NSO Group's flagship product named after the mythical winged divine horse in Greek mythology, an unique edge over its competitors in the global spyware market. Pegasus marketed as a world-leading cyber intelligence solution that enables law enforcement and intelligence agencies to remotely and covertly extract data from virtually any mobile devices, was developed by veterans of Israeli intelligence agencies. In August 2016, the Citizen Lab, an interdisciplinary laboratory based at the University of Toronto, reported the existence of Pegasus in cybersecurity firm Lookout, and the two flagged the threat to Apple. Until early 2018, NSO Group clients primarily relied on SMS and WhatsApp messages to trick targets into opening a malicious link, which would lead to infection of their mobile devices. In his October 2019 report, Amnesty International first documented use of network injections, which enabled attackers to install the spyware without requiring any interaction by the target. All devices, including iPhones, have been widely targeted with Pegasus through Apple's default iMessage app and the push notification service, APN's protocol upon which it is based. In October 2019, WhatsApp blamed the NSO Group for exploiting a vulnerability in its video calling feature. In December 2020, a Citizen Lab report flagged how government operatives used Pegasus to hack 37 phones belonging to journalists, producers, anchors, and executives at Al Jazeera and London-based Al Arabi TV during July-August 2020. Pegasus is now at the center of a global collaborative investigative project that has found that the spyware was used to target, amongst others, hundreds of mobile phones in India. The Supreme Court of India on 5th August 2021 made it clear that the truth has to come out. A bench of Chief Justice of India, N.V. Ramana, and Justice Surya Kant said the allegations of the government using Israel-based technology to spy on civilians, journalists, ministers, parliamentarians, activists were no doubt serious, provided the news reports were true. On 17th of August 2021, the government of India, represented by the Solicitor General of India, Tushar Mehta, told the Supreme Court that it had nothing to hide from the court. The Supreme Court, whilst issuing notice to the center, said the government should reply on the allegations that the Israeli spyware was used in individual phones, adding it would decide on forming a committee to investigate the allegations only after getting the center's response. In that context, Justice Surya Kant observed, we do not want national security to be compromised, but the phones of individuals were attacked as per their claims. Only a competent authority can respond to that. The right to privacy has been specifically incorporated in the United Nations Declaration of Human Rights. Article 12 whereof enacts, no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation. Everyone has the right to the protection of the law against such interference or attacks. Though not specifically defined as a fundamental right, the right to privacy has gained significant constitutional recognition in India. The courts have carved out a constitutional right to privacy by a creative interpretation of the right to life and the right to freedom. In a landmark judgment delivered by a 9-judge constitutional bench on 23rd of August 2017, in the case of Justice K.S. Puttaswamy versus Union of India, the Honorable Supreme Court of India held that the fundamental right to privacy was guaranteed under the Constitution of India. In the majority opinion delivered by Justice D.N. Chandrachud, the Supreme Court arrived at the following conclusion. Informational privacy is a facet of the right to privacy. The dangers to privacy in an age of information can originate not only from the state, but from non-state actors as well. We commend to the Union government the need to examine and put in place a robust regime for data protection. The creation of such a regime requires a careful and sensitive balance between individual interests and legitimate concerns of the state. The legitimate aims of the state would include, for instance, protecting national security, preventing and investigating crime, encouraging innovation and the spread of knowledge, and the preventing the dissipation of social welfare benefits. In a separate illuminating judgment, my dear friend Justice Rohington Nariman, who retired as the second senior-most judge of the Supreme Court of India on 12th of August 2021, traced the genesis of privacy law as follows. Any discussion with regard to a right of privacy in the individual must necessarily begin with Siemens case 77 ER 194. This case decided in the year 1603, when there was a change of guard in England. The Tudor dynasty ended with the death of Elizabeth I, and the Stuart dynasty, a dynasty which hailed from Scotland, took over under James VI of Scotland, 15, who became James I of England. James I was an absolute monarch who ruled believing that he did so by divine right. Siemens' case was decided in this historical setting. The importance of Siemens' case is that it decided that every man's home is his castle and fortress for his defense against injury and violence, as well as for his repose. William Pitt the Elder put it thus, The poorest man may in his cottage bid defiance to all the force of the crown. It may be frail, its roof may shake, the wind may blow through it, the storm may enter, the rain may enter, but the King of England cannot enter. All his force dare not cross the threshold of the ruined tenement. A century, just a minute. A century and a half later, pretty much the same thing was said in Huckle versus Money, 95 ER 768, 1763, in which it was held that magistrates cannot exercise arbitrary powers which violated the Magna Carta, signed by King John, conceding certain rights to his barons in 1215. And if they did, exemplary damages must be given for the same. It was stated that to enter a man's house by virtue of a nameless warrant in order to procure evidence is worse than the Spanish Inquisition, a law under which no Englishman would wish to live an hour. In today's techno-savvy world, computers and internet can be used to amass huge amount of data regarding people, profile it in various ways, commodity it, and deal with it in a manner which would violate personal privacy. Digitalization is steadily replacing storage of personal data beyond the contours of a physical form. Hence, all the data that we store or share are vulnerable towards misuse and invasion of privacy by diverse invaders who indulge in the act of stealing such data as shared through online by the users, either by use of malicious spyware or by various computer bugs, or directly from the website which stores it. Further, the information that the user shares on the social networking sites like LinkedIn, Twitter, Facebook, Instagram, etc., are very prone to be accessed by any intruder and are easily manipulated and misused, causing privacy intrusion. Cyber crimes which are committed by the use of the internet, whereby the computer is used as a tool or target, and is the most advanced form of privacy intrusion. Hence, privacy is on a high stake today. The annals of history are replete with many glaring records of state-sponsored inroads on privacy. John Foster Dulles, United States Secretary of State under President Dwight D. Eisenhower from 1953 to 1959, and described by Sir Winston Churchill as dull, duller, dullest, spied on American and Cuban nationals, amongst others, during the height of the Cold War. East German Ministry for State Security, better known as Stasi, which is headquarters in Lichtenberg, Berlin, under his infamous head, Erich Milke, who oversaw the construction of the Berlin Wall, spied on East German nationals, and particularly those living in East Berlin, for over 30 years. The Gestapo, with its headquarters in Niederkirchenstraße, former Prince Albrechtstraße, Berlin, under his brutal head, Heinrich Müller, had earlier in similar fashion spied on German nationals with impunity. The KGB, with its headquarters in Lubyanka Square, Moscow, was described by Time magazine in 1983 as the world's most effective information gathering organization. Its primary role within Russia and the satellite republics of the Soviet Union was to quell dissent by first identifying dissidents, promoting anti-communist political and or religious ideas, and then silencing them, often using extremely harsh and violent methods. For a long time, India did not have any special law dealing with cyber crimes and cyber privacy issues. It was only in the year 2000 that the Indian Parliament enacted the Information Technology Act 2000 to deal with cyber crimes and cyber criminals. The IT Act was subsequently amended in the year 2008 by the Information Technology Amendment Act 2008. The IT Act contains a number of provisions which protect the privacy of a person from online intrusion and exploitation. It provides for both fine and punishment by imprisonment in case of hacking, identity theft, and cheating by personation and offensive emails. Apart from this, the IT Act also provides provision for data safety. The government of India has notified the Information Technology, Reasonable Security Practices and Procedures, and Sensitive Personal Data and Information Rules 2011. The rules only deal with protection of sensitive personal data of information of a person like passwords, bank account or credit card or debit card details or other payment instrument details and physical, psychological and mental health conditions, etc. The rules provide reasonable security practices and procedures which the body corporate or any person who on behalf of the body corporate collects, receives, possesses, stores, deals in or handles information is required to follow while dealing with personal sensitive data or information. The Parliamentary Standing Committee on Information Technology, in its 52nd report on cyber security and right to privacy, said that a significant increase in cyberface activities and access to internet use in India, coupled with lack of user-end discipline, inadequate protection of computer systems, and the possibility of anonymous use of ICT, allowing users to impersonate and cover their trends of crime, has emboldened more number of users experimenting with ICT abuse for criminal activities. The committee expressed the opinion that this aspect has a significant impact in blunting the deterrence effect created by the legal framework in the form of the IT Act and allied laws. The committee has listed several offenses which fall under the purview of cyber crimes and the remedies available within the existing legal framework. Cyber stalking or stealthily following a person and tracking his internet chats is punishable under Section 43 and 66 of the IT Act 2000, while video voyeurism and violation of privacy is a crime under Section 66E of the IT Act with a punishment of 3 years and fine. The government of India constituted a committee to propose.
You're running out of time.
Yeah, just a minute. The government of India constituted a committee to propose a draft statute on data protection. The government has placed the Personal Data Protection Bill 2019 PDF bill based on the draft proposed by the committee on the anvil. The PDP bill proposes a broader reach. It will not only apply to persons in India, but also apply to persons outside India in relation to business carried out in India. The PDP bill proposes to apply to both manual and electronic records. The PDP bill proposes creating a data protection authority in India. The authority will be responsible for protecting the interests of data principles, preventing misuse of personal data, and ensuring compliance within the new law. The PDP bill proposes to protect personal data relating to the identity, characteristics, traits, attributes of a natural person, and sensitive personal data such as financial data, health data, biometric data, genetic data, religious or political beliefs, etc. And finally, to conclude, the need of the hour is that the PDP bill, which is sadly languishing in Parliament, be passed without any further delay, and the assent of the President be immediately given thereto. If the PDP bill sees the light of the day, it will certainly provide far greater protection from the invasion of privacy by misuse of technology. Thank you very much.
Oh, thank you very much, Anup. What a wonderful talk. Thank you so much. There is a question that's come in from Sanjay Rikhi. Sanjay, please ask your question.
Okay. Thank you for the opportunity. And of course, after having heard very patiently our learned speakers, really very commendable and very informative, I think, presentations. My question is on the basically the very basic one. What are the factors contributing towards technology abuse? Any research conducted on this to take measures to combat technology misuse? That's one part of my question. Followed by, is there any research on ongoing behind on the going behind the reason for technology misuse? It's a similar question, I think, which I asked just now. And the last one is on the data leaks through exploitation of technology leading to adversely costing privacy and steps to control them. Are the laws strong enough to curb them? So I hope I've been able to make my question a little clear. It's divided into three parts, basically going behind the root of technology misuse. And are the laws good enough? I think that partly has been addressed by Bose, Mr. Bose, that the PDP would give the answer. But I think the effectiveness of the use of this PDP and curtailing the leaks holds the key. So my request would be if you would like to throw some light on the questions I have in my mind. Thank you.
Sarah, would you like to go first?
Yes.
Yes, I think, when we talk about crimes, there's a multitude of crimes. It's one crime is not the same as another crime. We've got sort of cyber enabled, we've got cyber dependent crime, so I think it depends, first of all, on the crime. A lot of the crimes may be committed within one country, but when they start crossing borders, there isn't the legislation, particularly when it starts to cross outside a country, to actually bring any perpetrators to justice. It's very, very hard in the cyber environment with some of this technology, particularly on the internet, to be able to detect and then prosecute successfully any person that's guilty of these offences. But I think there's a multitude of legislation that exists, but it varies from country to country. But there isn't the international probably strong approach to deal with this when it goes outside the country in particular. But when you talk about sort of technology abuse, it's so vast, technology is so vast, and this is one of the factors, as I kind of said, but you kind of start with the basic technology. A sat-nav's quite a basic one, but then you've got the satellite system that goes with it. Then you've got the cyber environment. So I think it's very, very hard. With regards to, is there any research that looks at this? It's still a criminal intent, even though it's perpetrated by technology or by cyber means. So it's still that sort of criminology intent. Can you transform some individuals? I think it depends on the offences. When you're looking at child sexual exploitation, are you going to be able to sort of stop people? I think that's kind of debatable. So I think that would be my answer. Hopefully I've answered a little bit, but I'm going to hand it over to somebody else as well.
Anup, would you like to take it on now? Anup, you're muted. You're still muted.
Okay, sorry. I think Sarah touched upon a very important aspect, that is the jurisdictional area, you see, because like for instance, you may have laws in your own country to protect its own citizen, but internet governance and the jurisdiction of states, now that's a very important area that has to be looked at. For instance, China has laws which protects its own citizens against any kind of privacy invasion, but which are committed on Chinese territory. But what about Chinese who are committing crimes outside Chinese territory? And what are the safeguards that, say, for instance, Indian laws have against such intrusions? Therefore, this jurisdictional issue has to be sorted out, and this can only be sorted out if all countries put their minds and heads together in forums like the United Nations, where we can evolve a kind of international strategy, sans jurisdiction. We have to address ourselves to these, trans-border violations, you see. Like, can you sit in India and take any action against a Chinese hacker sitting, say, in Singapore or in Hong Kong or somewhere? You can't. Therefore, we have to have some kind of a consensus between, enlightened states, you see. I don't talk of rogue states who will in any case never cooperate, to put their, as I said, minds and heads together in forums like the United Nations and work out an international regulatory modus for tackling such problems. I think I'm adding that to what Sarah has said. Thank you very much.
Thank you very much. We have amongst us Mr. Pannu, who's been heading the Reliance Group Security. And during his career of so many years with Reliance, I'm sure he's had countless number of occasions where information has been attempted to be stolen from Reliance. Mr. Pannu, can you throw some light on how you combated the problems and what were the legal issues that you were confronted with while combating them? You are muted. Unmute yourself, please.
Am I audible now?
Yes, absolutely.
I tell you that along with the development of the technology and the technology going into the hands of the culprits, the thieves, we've been trying to keep a pace with the preventive systems through the technological preventive systems. But despite that, there has been some cases here and there where some kind of a breach has been happening, reported. Now, that is one aspect. Most of the industrial houses, they have to take adequate preventive measures, but it's never been adequate because the thieves is always a couple of steps ahead of the guys who are to catch them. After hearing both the presentations, to tell you frankly, at times I feel a little panicky because the technology has enormous power to do bad things, to do destructive things, as it does good things also. For example, there are instances, and more likely they are going to happen more. For example, destruction and sabotage of the power grids of nations sitting tens of thousands of kilometers away. For example, hijacking and destruction of the aircrafts from remote. For example, using technology for biological, chemical, nucleological in the world, in my understanding, that such culprits can be brought to justice effectively, because if something happens here, some other nation, whether rogue or unrogue, will and do provide safe havens to such culprits. Mr. Anup has partly touched upon that aspect, but to me, I don't find any very effective countermeasures to prevent and protect the humanity from such culprits. I don't know whether the UN is effective enough, because UN has never been effective to bring the rogue nations or such big culprits to motion. So that is my apprehensions, which I throw it open to get some satisfaction. Whether it's Ms. Sarah or Anup.
I think it sort of links back to what was said. You're always going to have people with criminal intent, and you're unfortunately always going to have nations that don't always sort of come into line with the rest of society, that sort of have this sort of propensity to want to misuse technology. There's a distrust of other nations. We've had this sort of like through history. Unfortunately, history does repeat itself, just technology makes the consequences more severe. So, the more advanced we're becoming, we make the same mistakes. We will still have wars, we will still have pandemics, but technology is actually going to make the consequences more severe. So, if we're looking at sort of some of this human interfacing with machinery, I mean, that's going to be as we go sort of further ahead. But even the simplest technology in the wrong hands can be misused. And that was kind of the part that I was saying, that, even a very, very simple piece of technology. So our cars have a lot of information. Our routes are known, the sat nav, there's ANPR systems, automatic number plate recognition systems. Technology is all around us. But if it's in the wrong hands, that's when the consequences can be negative. However, as we said, it can actually benefit society as well. So most technologies, if we look at it from both perspectives, so if you take UAVs, for instance, humanitarian aid, reducing the likelihood of people actually coming into sort of dangerous situations by going up tall masts because the drone can do it. Fantastic advantages. But actually in the wrong hands, and I know sort of India sort of suffered this quite recently, it can be quite devastating. So in the wrong hand, a drone is a weapon, the same as an aeroplane was used as a weapon. So that was kind of the point that I was making. We have advantages with technology, but it can be misused. And I think our next challenge, we haven't actually spoken about, that our next challenge is going to be space, because we've had conflict on Earth, But the next one, we're looking at sort of those Star Wars sort of type of, defense systems, or because that's going to be the next challenge. You're going to have nations that are going to be trying to get the minerals. I mean, there's a planet that's, an asteroid, and sort of, when we're looking at some of these that have got the wealth within them, then unfortunately you're going to have unscrupulous nations and unscrupulous people want that wealth.
Anup, do you want to add anything? Anup, you're muted.
I think Mr. Pannu's remarks were very illuminating. In fact, I had the privilege of working very closely with Dhirubhai. And even in those days, Dhirubhai laid paramount importance to the use of technology. I remember even in the early 90s when we used to have conferences, there used to be the legal head and the company secretary Reliance with a special machine which Dhirubhai had installed. And there used to be lawyers from England, from America, from India, all in talking and discussing on that machine. Even at that point of time, he had thought of the power of technology. But as I told you, technology often fails, particularly when we talk in the context of extraterritorial jurisdiction. That will be the greatest challenge that all of us as lawyers or free or enlightened citizens of the world will face. How do we tackle this problem? How do we tackle countries like China and others where the laws are only meant for their own citizens and they don't protect? You see, the Chinese sort of invading the privacy of others in other countries. Therefore, we have to look at this very, very objectively, that we have to look at this extraterritorial angle with great seriousness, you see, because therein, I think, would lie the remedies that we are seeking today. Thank you very much.
The next question goes out to General Sapra.
Really speaking, sir, it's not a question. I'd like to make a small statement and then conclude by saying so. This is nothing new that is happening, and the examples given by Anup from 2013 to latest Pegasus and all. I'll take you back to, I think it was 70s or something, Watergate scandal. Very famous, Watergate scandal. Start with US. What was Watergate scandal? Just because the technology was not that ripe, they used bugs and all those rooms. And Watergate was the thing, I think it started from a hotel or something where the first time news broke out, that was a hotel named Watergate. So it became a Watergate scandal. And since the Nixon never wanted to get impeached, so he quit. He quit. That's number one. Number two, come back to India. I think Kargil operations. Something in the Kargil operations happened. And there were two very senior officers of Pakistan Army. One was in China and one was in Pakistan. And their conversation is on. And they say, Miyaji ko pata hai what is happening? Sorry, I'll translate in English also. Does the Prime Minister know what is happening? And the other chap says, no, I don't know what is happening. Now, this was all being recorded in India. So saying that who's got more power and who's got more reach, and that cassette next morning in the media, I think, was blown up by the Indian military that see this cassette and see this recording, what they are talking. So my only point is, from ages immemorial, this is happening and this will keep happening. It will never stop. My take is that we should keep our defense ready. And I think a time has come when very senior dignitaries, when they talk, firstly, of course, when you enter an office of a dignitary, you are searched. But suddenly you'll find that a lot of times these people are walking, sitting in the lawn, sitting in gardens. So walking and talking has become a norm. That means we are going back to the Stone Age. So if you think you can't, your privacy is secure by some technical means, I'm not in agreement. There are ways and means there will be breach of security at all stages. We have to keep our defense ready. As far as I'm concerned, my country will be attacked too. I have to keep my defense. Similarly, this IT thing will be breached time and again, and I have to keep my defense. That's my take on that. There are no questions as such. Thank you, sir.
Espionage in the corporate world has become very prevalent. Stealing of secrets from one company to the other.
Yes.
That's a more commercial sort of a situation which we see nowadays. What is your take on it, Anup? And what are the laws that will prevent it occurring in future?
See, as Mr. Sapra said, we may have laws and technology, but ultimately criminals always find a way out, you see. It's very difficult. Laws by themselves cannot be the answer. There has to be a public awareness. You see, in so far as corporates are concerned, you are aware of things like insider dealings, you see, where people are even discussing with their competitors the trends in the shareholding pattern of companies, in the way the prices of shares go up and go down. And on that basis, competitors plan how to launch a campaign against, we've of course had many corporate battles, and even battles within families like the Chabria case when Manu and Kishore Chabria fought each other. Now you have the famous Kirloskar brothers who are fighting, you see. Now, and then in such battles, what happens? You always try to get information from the other side, you see. And there are always people within the system. How do you catch the moles? Now, can you have a law to catch the moles? It's very difficult. Like suppose I have a company, let's say Reliance. There is somebody sitting in Mukesh Ambani's office. Like, in the old days, the secretary to the German Chancellor, Willy Brandt, was spying for East Germany. And it was many years later, it was found out that there was a mole within the Chancellor's office. And with all the security, with all the surveillance, the Germans could not nab this person till after a very long time, you see. And therefore, according to me, laws by themselves, there are several corporate laws on insider dealings, laws on, how you deal with your competitors, trade rivals. There are laws dealing with trade rivals, that if you go to the competition tribunal, can a complaint be filed by a trade competitor? No, it will be dismissed immediately, because we'll say this case has been filed by a trade competitor. But laws are fine, they have their own place. But we as citizens have to rise up against all this, you see, and it will be very difficult, I'm telling you, to find these moles within the corporate system. I know even...
how do you protect the children from, how do you prevent the privacy of children from falling into wrong hands?
I think you have raised a very important point, you see. Now, this has been a subject of great debate all over the world. That does a child have a right to privacy? And according to me, when I say every citizen has a right or a fundamental right to privacy, that would also include a child. How much time this child spends with his or her parents, or where the parents are separated, how much time he will spend with the mother who is separated from the father. So all that is very important. And I think this is an area where the United Nations has to go beyond the laws and regulations it has relating to child rights, you see. Now, the child rights have to be expanded and enlarged to bring within their purview rights to do with child privacy. That's important. The privacy of the child is also a matter of fundamental importance. And I think the privacy of a child, what the child should eat, what the child should wear, which shop the child should go to, how much time a child will spend with one particular parent or with a friend. See, all these matters are matters which even a young child should be free to decide. And even the parent should not interfere, and there should be law also protecting the privacy of a child and seeing to it that the child is insulated from an invasion to his privacy. So I think this is an area where India and other countries have to go to the United Nations and enlarge the scope of the child laws that are already in place and add greater punch to such laws so that the privacy of a child is protected and sustained and safeguarded. Thank you.
Thank you very much. I think we run out of time on question and answers, but the last question goes out to Colonel John Chinatra. He's got a very interesting question. John, you're muted. John, unmute yourself, please.
Yeah, I may not be using the right terminology, but in the GDPR, I remember there was a term called the right to be forgotten. That means when a website has to take my approval before my personal data is captured by them. Even after that, at any point of time, I can instruct the website to forget all the data collected. Is it correct? Is it true? And what are the implications?
Sarah, would you like to take this on, please?
Yes, so there is a right to be forgotten. Obviously, when you're looking at sort of settings, these days they should be sort of minimally set, and then you have the opportunity to go above. So it should only be necessary data. But does it work in reality? I don't know, because, you know, I gave you the sort of classic example of Amazon, and, you know, I think many of us during lockdown, we probably took to using websites a lot more. And we still get those emails. It does remember you. Every time I said about Lockhart's principle, and that is everywhere you go, you leave a trace. And hopefully that won't be sort of abused, but unfortunately it will be, even if it's not by that company. And there is a potential for somebody else to sort of, you know where you've been, the sites you've been. Just want to pick up on something else that was said earlier. You know, with legislation, it's always behind technology. So it reacts rather than is proactive. And I think we need to be looking a little bit sort of further forward. We need to be sort of projecting what are some of the challenges that are going to come with the technology, and be prepared. And that kind of fits in with what was said earlier. You know, unless we still start to identify some of these risks before they occur, then the legislation will never be sort of adequate. But also, you know, and just picking up on something that was also said earlier, you know, your home is your castle, that concept going back that was recalled. Yes and no, because I kind of touched on this, and hopefully I made myself sort of clear. If we think back to the 1830s, that was the principle, and even earlier. But we think about sort of the policing perspective, and they wouldn't necessarily cross over that threshold. And it was Anup said the same phrase about crossing over a threshold, because that's your privacy. But there are times when your privacy in your home has to be broken because you're committing crime using the internet. So we have this dilemma, which is the point I was making. If you are in your own home and you are undertaking offences such as child sexual exploitation, then your privacy has to come second to the victim's privacy, you know, to the offences that's being committed. So I think that's where we have that dilemma that I was trying to identify to you on some of those concepts. You know, if your home is your privacy and nobody can enter, then you can perpetrate offences using technology, and we simply can't have that, you know, because we have to be held accountable for crimes as much as we possibly can.
Thank you, Sarah. I think I'd like to thank everyone present here, and I'm going to hand over the proceedings to the President to conclude the session, please.
Thank you very much. It was a very, very illuminating session. Sarah basically referred to two phases, the prior to 9/11 and post 9/11, and then touched on the corona phase, as how these circumstances made us or made the governments compromise or interfere with the individual privacy, prior and post. I was transported to a courtroom while listening to Anup. He has given a treatise, a beautiful sort of compendium for me, starting from long years of various rulings by the courts and how they have tried to explain the right of privacy. Basically, I'll just like to summarize into two. First is that whether the government agencies can interfere subject to so and so, they are subject to this condition. That is a question of subject, means that comes in the realm of the government. If there is a threat to sovereignty, threat to national security, then who will interpret the national security? Who will interpret the threat to the security? So these are the handles. Somehow, how they have to be, these handles are not to be used as an instrument to indulge and know about the privacy of individual and the freedom of individual. This is about the laws. Second part is, as Anup has very nicely pointed out, that there are laws. They are being, from USA IT Act amended now also has come, and still there are lacunas. Now the Right to Privacy Act is pending. and they're all asking that this should be codified as far as India is concerned. The Right to Privacy Act is still not codified. So therefore, still, if you have to go by legal rights, I'm talking. So there are two ways. One is that your enemy or your competitor or a businessman may like to pry into it. For that, you should have your countermeasures, your own countermeasures as to how he is not able to interfere, as Panuji pointed out. Your countermeasures should be ready, technical countermeasures, so they are not able to impinge on your right to privacy. But the laws have to be there because there is a threat, there's a fear of punishment. And therefore, if the laws have a absolute, there's never an absolute law, there's never an impeccable law. But still, there are laws, and the laws in various countries do give right to privacy a very great importance. So such laws, right to privacy, need to be codified and made in India also. Sarah has, I have read your bio. You have given a very nice, it's a paradoxical sort of thing. You say dilemma. One side you say in your findings that the human rights and security is a paradox in one of your theses. Human rights and security means she is herself saying, yes, for security, you may have to impinge on the human rights, but human rights are very important. So this paradox continues. These all three divided. Then you come to children right. He is very beautiful pointed out. I think Anupji has pointed out some time back that one wanted to determine the genes of a child. Why should he be subjected to such an examination? Because he is not being asked. The right to privacy for the children should be there. To conclude the session, it is beautifully explained. There have to be countermeasures as far as impact of these concerns, as far as interference of the technology, modern technology into your privacy. There should be countermeasures which should be available. You said probably technical countermeasures should be available. Legal rights have to be there. Otherwise, there will be no fear. But legal rights should not have these subject to this. If they are subject to, then that subject to the condition should be stipulated, and stipulated in a way that nobody uses that, either the government or any private person uses it to advantage and impinges, interferes, or some other compromises the privacy of another individual. With these words, I think the total session has been very illuminating. The emergence is there, that there have to be laws also, there have to be countermeasures also, and yet we have to yet to find out as to how to go about. I think it needs with such a erudite thesis given by Anu and Sarah, I think, Pawan, we have to find out some solution and some recommendations as to how it should be done. Those recommendations may be only for the private individual or the enterprises. With these words, I once again thank both the speakers for very illuminating speeches, very illuminating debates. Next sessions of ours, the next seminar, interactive session, is on cyber disruption and protection. And it is being addressed by Dr. Pawan Duggal, who is considered to be one of the authorities, known authorities on cyber disruption. This is an interactive session, and this interactive session is due on 27th August, 6 p.m. I request, it's only for 1 hour session. After that, we have next webinar is due on the 10th of September, corruption in criminal justice system. Criminal justice system, please mark it. It is not a police enforcement, it's not A, B, C. The entire criminal justice system somehow or other is tainted. And we discuss on this subject. We're getting some eminent speaker. This is due on 10th September. With these words, I thank both the speakers very much, thank all the delegates, and thank Mr. Pawan Ahluwalia for giving me a sort of impetus to organize this webinar and have the deliberation from these speakers. Thank you very much indeed. Thank you so much.
Thank you. Thank you.
Thank you, Sarah. Thank you, Anup. Thank you very much, everyone. Thank you all who attended.
Thank you, speakers. Thank you, sir. Thank you, everyone, sir.
Thank you all. Thank you, Sanjay.
Thank you, everyone.
Thank you all.
Thanks, sir. Great day, sir. Have a great day.
Thank you,
Thank you, sir.
Sipalji and Pawan. And wonderful seeing you, Sarah, after what seems ages.
I know.
Well, I
Hopefully
did see you the other day, just 2 days ago, but that was fleetingly, you know.
hopefully we can meet in person.
But all our interactions are now virtual, you see. Like tomorrow I have a matter in the Bombay High Court is virtual, you see. Sitting in Delhi, I'll be now before the Bombay High Court. So the world is changing, you see. The world is changing.
Thank you.
Thank you.
Thank you.
Thank you, everybody. Thank you, sir.
Thank you, sir.
God bless you all, you see.